All right, everybody, welcome back for another deep dive.
It's great to be back.
Yeah, today we're tackling something that I think we all kind of feel a little bit intimidated by.
A little bit, yeah.
We're going to be talking about legal jargon.
Oh, yeah, legalese.
Yeah, exactly. Legalese.
We all encounter it and
We all see it.
every day.
Yeah, in the news.
On TV.
We see it in even just like forms that we have to fill out.
Absolutely.
And it can feel like you need a law degree to even understand what they're talking about.
Yeah, exactly.
So we pulled 10 terms straight from the courtroom that we're going to break down today.
All right, I'm ready.
All right, so we've got arraignment liability exhibits,
Okay.
discovery docket, prima facie evidence adjudication,
Big words.
contingency fees, peremptory challenges, and writs.
Wow, that's a mouthful.
It is a mouthful. And what's so interesting to me about these words is how they touch upon like so many different aspects of the legal system.
Yeah, they really do kind of cover it all, don't they?
F&P.
Yeah, from the very beginning of a case to the, the final verdict.
Mm-hmm.
So it's like you said, it's kind of intimidating.
Yeah.
But once you break it down, you can see how these terms represent kind of like the building blocks
Yeah.
of the justice system.
Foundation.
Yeah.
Yeah. All right, well, let's unpack this, starting with arraignment.
Okay, arraignment.
Arraignment.
So picture this, right? You're standing in a courtroom.
Okay.
It's your first official appearance.
Oh, boy.
The charges against you are read aloud.
Uh-oh.
The judge looks down at you and says, "How do you plead that my friend is the arraignment?"
So this is where, like, the legal process
This is where it kicks off.
kicks off.
That's where it all begins.
I mean, it sounds pretty nerve-wracking.
Oh, absolutely.
You're basically setting the stage
Yeah.
for your entire defense at this point.
You're setting the tone for everything that follows.
But you mentioned there are options.
Yeah.
Beyond just guilty or not guilty.
Right. So you've got your standard guilty, not guilty. But there's also this thing called no contest.
No contest.
No contest.
What does that mean?
So no contest, it essentially means that you're accepting the consequences without actually admitting guilt.
Interesting.
And this is sometimes used in high-profile cases.
Right.
Where someone wants to avoid a very long public trial.
Yeah.
But they still want to kind of move on with their life.
They just want to get it over with.
Yeah, exactly.
Okay, makes sense. So you're not saying I did it,
Right.
but you're also not fighting it.
Exactly.
Okay. All right. Next up is liability.
Liability.
This one we hear all the time.
A lot of the time, yeah.
But how does it actually apply in the legal world?
So liability boils down to responsibility.
Okay.
Who is legally accountable for something, for an action, or even for a failure to act.
So like if I back into my neighbor's car,
Exactly.
that's me being liable.
That's civil liability.
Okay.
You would probably have to pay for those damages. Now, let's say you intentionally ram your car into your neighbor's car.
Okay, so now we've got a whole different situation.
Now you've moved into criminal liability.
Criminal.
Yeah. One is negligence backing into the car.
Yeah.
The other is intentional harm.
Okay.
So civil liability often deals with disputes between individuals or organizations.
Got it.
And usually it involves some kind of financial compensation.
Okay.
Criminal liability is breaking the law.
Right.
And that carries much heavier consequences.
Yeah.
Fines or even imprisonment.
Okay, so two very different types of liability.
Very different.
But it all comes back to responsibility.
Responsibility, accountability.
Got it. Okay. Now, for something that sounds straight out of a courtroom drama, exhibits.
Exhibits, yes.
Exhibits.
So exhibits are the tangible pieces of evidence.
Okay.
In a case, it's the smoking gun, so to speak.
It's the stuff that you can like hold,
Yeah,
kind of
exact.
see and touch.
It could be anything.
Yeah.
It could be a document, a photograph, a weapon, a piece of clothing, a strand of hair.
Like in the O.J. Simpson trial?
Yes.
The glove.
The glove.
That was an exhibit.
A very famous exhibit.
Right. And so these exhibits are really important.
They are. They can make or break a case.
Yeah, because it's not just somebody saying something.
Right.
It's actual proof.
It's something real.
Okay. All right. Discovery.
Discovery.
This one always makes me think of like a detective show.
Yeah, it's all about gathering information before you go to trial.
Oh.
Both sides are exchanging information and evidence to build their case.
So it's like each side is trying to figure out what the other side has.
Exact.
And they're also trying to poke holes in the other side's argument.
Yeah, they're looking for those weaknesses.
Oh, okay. So it's a very strategic time.
Very strategic.
All right, docket. This one makes me think of like a to-do list.
Yeah, it's basically the court's calendar.
Okay.
The master schedule of everything.
So it's got every single case.
Every case, yeah.
And all the deadlines and everything.
Yep, all the proceedings, filings. the status of each case. It's all on there.
Can you imagine the organizational nightmare?
You don't even want to think about it.
If they didn't have the docket.
Yeah, it'd be chaos.
All right, well, let's move on to prima facie.
Prima facie.
This one sounds so fancy.
It does sound fancy.
But I feel like it basically means like a first glance.
You're on the right track.
Yeah.
Okay.
Yeah.
So prima facie evidence is basically evidence that's strong enough
Okay.
to support a claim
Okay.
at the very beginning.
At the initial stage.
Yeah, like when you're first presenting your case.
So it's like a good opening argument,
Exactly.
but it doesn't necessarily mean you're going to win.
No, the other side can still present counter arguments.
Okay.
It's not a slam dunk.
So prima facie is like you've got a good foundation,
Yeah,
but you still have to build the rest of the house.
exactly. You got to have those walls, the roof.
Okay. All right. Adjudication.
Adjudication.
This one just sounds like making a decision.
Yeah, it's about the whole process
Okay.
of resolving a dispute.
So it's not just the judge saying guilty or not guilty.
Right. It's everything leading up to that.
So it's like examining all the evidence
Yeah,
and, hearing the arguments from both sides
exactly.
and then ultimately making that judgment.
Yeah, it's the court doing its job.
Okay. All right. Contingency fee.
Contingency fee.
This one I always think about like all those personal injury lawyer commercials.
Injured in an accident.
Yeah, exactly.
Yeah, that's contingency fee.
So what does that mean?
So a contingency fee means that the lawyer only gets paid
Okay.
if they win your case.
Also, it's no win, no fee?
No win, no fee.
That's high stakes.
High stakes for the lawyer.
Yeah.
But it also makes it so that people who can't afford
Right.
to pay a lawyer up
Yeah.
front
Yeah.
can still have legal representation.
So the lawyer's basically taking on the risk
Exactly.
that they might not get paid at all.
Yep, that's part of the deal.
Wow. All right. Peremptory challenge. This one sounds like a power move.
It is a bit of a power move.
During jury selection.
Yeah, this is when each side
Okay.
has a certain number of these challenges
Okay.
where they can dismiss a potential juror
Without even giving a reason.
without giving a reason.
So it's kind of like they just don't like the vibe.
Right, they're trying to shape the jury.
To be more favorable to their side.
Exactly. But it is a little bit controversial
Yeah. I can see how that could be.
because you could use it to discriminate
Right.
against certain groups.
Okay. Yeah. So there's some strategy involved there,
A lot of strategy in jury selection.
but also some ethical considerations.
Yeah, always.
Okay. Our last term, writ.
A writ.
This one sounds like it came from medieval times.
Yeah, it sounds very formal.
Yeah.
So a writ is basically a written order
Okay.
from the court
Okay.
commanding someone to do something.
Or to not do something.
To not do something, right?
So it's like the court's way of saying this is what you have to do.
Yeah, it's making their decisions official
Okay.
and enforceable.
And there are different types of writs.
Different types. You've got habeas corpus,
Habeas corpus.
which is challenging unlawful detention.
Okay. So if someone's being held in prison and they shouldn't be,
Exactly.
they could file for a writ of habeas corpus.
That's right.
Okay. And then you said there was another kind.
Yeah, you've got a writ of mandamus,
Mandamus.
which orders a public official
Okay.
to perform their duty.
So it's like telling someone you have to do your job.
You got to do your job.
Wow. Okay, so we've explored all these legal terms, and I feel like I can actually hold a conversation about the law now.
Me too. I feel like we've successfully decoded
Decoded?
some legalese.
Yeah, and you know what else?
What's that?
I feel like I'm going to be able to understand those legal dramas
Oh, yeah,
a lot better
definitely.
and not feel so intimidated
Exactly. You can impress your friends.
with all my new knowledge.
All that legal jargon.
All right, well, I hope you all learned something today.
Yeah, this was fun.
This was great, and we'll be back with another deep dive soon.
See you next time.
Bye, everybody.
Bye.